going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. We made it. We made it to the end of yet another week. And I hope you guys had a great week. Hope you guys have great weekend plans. Don't do anything dumb. Tell you this every Friday. Don't do anything dumb. I will cover you in court and I will brag about knowing you. You don't want that. So don't do anything dumb. All right. You guys want to watch some court? I want to watch some court. See, what do I have tonight? We're going to start off with a weirdo. Second guy's a little bit of a weirdo who actually might be right. He might actually have a lawsuit that has some merit. We'll find that out later. And then we're going to finish up with some weirdos. So we got some court weirdos tonight. Hopefully you guys are ready for it. That's all I got. You guys ready to go? Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Mr. Assadi, I need you to sit still and not move.
Yes, ma'am.
Thank you. Calling the City of Royal Oak versus Ismail Assadi. This is the date and time set for the arraignment. Your appearances, please.
Good morning, Your Honor. Edith Blakeney on behalf of Ishmael Assadi. Your Honor, my client is here standing mute, waiving the formal reading, is requesting MIDC attorney agrees to participate virtually in this proceeding. And sir, can you state your name for the record?
My name is Ishmael Ahmed Mohamed Assadi.
Good morning.
Good morning.
And also, Your Honor, his address is changed. I did enter that into the chat along with his telephone number and email address.
Okay, are we waiving the formal reading?
Yes, Your Honor.
Okay, waive the formal reading if you make a representation to the court that you've explained the nature of the charges, the possible penalties, and your client's constitutional rights.
I have, Your Honor.
Okay, does he stand mute or a plea of not guilty?
He does. Mute.
Which one?
Mute.
Okay. Could you mute somebody? Ms. Furtado. Thanks. Okay, so we'll waive the formal reading. Defendant stands mute. A not guilty plea to enter. His assigned counsel request is granted. Counsel shall be assigned. Please let me update the address, please.
Yes, Your Honor.
Okay, give me a minute to copy it.
Let me know. I mean, my internet is known for being awesome, so it's definitely not on my end. I have no idea. Hopefully it's not an issue. It just resolves itself. I have no idea though, Katie. Rich, 13 months. That is awesome, Rich. Thank you so much, Rich. You are awesome. 13 months. Dang. Heather.
Is that his email address as well? Or is that?
Yes.
Yeah, I forgot to cut out this dead time.
Okay.
Apparently. But we're gonna just knock out these milestones while it was dead time. Mary, thank you so much for the 3 months. You are awesome. Thank you. All right, not dead time anymore.
Waive the formal reading, stand mute, not guilty plea, assigned counsel. I have his address. What do you have to say about bond and bond conditions, please?
Your Honor, my client is 31 years old, single, unemployed, does have a criminal history, a slight criminal history. He did appear timely today, so I do not believe he's a flight risk. Unfortunately, I don't have the police reports. I don't know the details of the police report, but
I think on the it's a ticket, and it states
Okay.
that he refused to leave Leo's Coney Island despite many instructions and requests to do so.
Okay. Well, that's a nonviolent offense, Your Honor. I would ask for a personal bond.
Okay, 1 second. I want to review this.
Man, I cut
Is
out.
he still out on probation out of the Canton, the 35th District Court? Do you know?
Are you still on probation?
No, I am not. I actually got discharged over 2 months ago.
Okay.
2 months ago, he got discharged from probation. You know what? He's a solid type of guy. He waits till he's off of probation before he commits another crime. See, not all people are court geniuses. He's just a weirdo.
I finished my probation and got discharged.
Okay, 1 second, please.
Yep.
The court is setting the following bond and bond conditions. It's $5,000 personal bond with the following conditions. Sir, you must personally appear for any exam, arraignment, trial, or sentencing, abide by any judgment entered in this case, surrender to serve any sentence imposed. You are not to leave the state of Michigan without permission of this court. You are not to commit any crime while released. You shall immediately notify the court in writing of any change of address different from the Main Street address or a telephone number than the one provided ending in 9913. You shall not use alcohol, marijuana, or any other illegal controlled substance. You shall alcohol test ETG 2 times per month with pretrial services. You shall not possess a firearm or other dangerous weapon, and you shall not go to Leo's Coney Island on 110.
Hey, Holly, thanks for hanging out with us. True Northern Cali. Is that Oregon or Washington? I don't know. I thought that was funny. It was funny in my head. Thanks for hanging out with us tonight.
In South Maine. We'll set this matter for a pretrial conference.
Your Honor, I'm
Yes, sir.
sorry to interrupt you, but I work there. I have pay stubs I can show you right now, or send it to you. Send you the documents that I work there. So stop.
Yeah, no. Yeah, you worked there. They trespassed you from there. I don't think you're going back to work.
Me from going there will stop me from going to work.
Well, how is it
Sir,
that
but you said you were unemployed.
I'm employed at Leo's Coney Island. I have my paychecks that I can provide you right now on my position.
Um,
I'm ready to go in a breakout room and talk that out?
Thank you, Your Honor.
Back on and recalling 2500285. This is the City of Royal Oak versus Ismail Ahmed Mohammed Assadi. Okay, Ms. Blakely, what is the lay of the land here?
Your Honor, I spoke with my client regarding the facts and circumstances that I understand from you right now, Your Honor, understanding
Okay,
that
this is what the ticket says. Advised on trespassing numerous times from Leo's 110 South Main, refused to leave, yelling, causing alarm in front of multi people inside and out. Misdemeanor trespassing, misdemeanor disorderly. Okay, that's all I have before me.
And I have the right to face my accuser as well.
Sir, stop, please, stop. Oh, thank you, Your Honor. Okay. Your Honor, my client.
Mr. Assadi, don't speak. Do not speak. Let your counsel speak for you, please. Thank you. Go ahead, ma'am.
Your Honor, my client just explained to me that it kind of slipped his mind that he was working at Leo Coney Island. He is employed there.
Answer, sir, please. Every time you open your pie hole, you get it worse trouble. So stay the course.
that this is a unique situation, and if there is a disorderly or a trespassing, the typical protocol is to not a no contact with that place where the alleged.
I'm very confused as to why the employer would call the police on an employee who's causing a problem to the business, and that the at-will employee would continue to be employed. It's a head scratcher.
I'm confused about that as well. And I did explain to him possibly if the owner contacts the court, maybe the no contact can be lifted, but.
Oh, I had my microphone on top of my head. That would take me a little bit to find. That clip is probably 6 months old now. I don't even know if I could find it if I wanted to, but I played the whole clip at one point. I don't even really remember what it's about, to be honest. It's just a funny little soundbite.
As far as protocol and what I'm familiar with the court, there may have to be a no contact order. I'm just here. This is arraignment. So I know what Your Honor has given me. I have not had any time to investigate.
Right.
This is all that I know. So at least for a temporary time, I do believe as typical protocol is, he will have a no contact. I'm at a loss.
Okay. All right, the court is continuing with the bond conditions. I was reading them on the record when this assertion came in that the defendant is employed by Leo's Coney Island. So it's a $5,000 personal bond. No money's due at this time. The conditions, as I was going through them, are the standard court rule conditions. In addition, you are not to use alcohol, marijuana, or any other illegal controlled substance. You shall ETG alcohol test 2 times per month through pretrial services. You are not to possess or purchase a firearm or other dangerous weapon. You are not to go to Leo's Coney Island unless the owner and employer advises the court in writing that defendant may return to Leo's for work only.
Thank you.
And no recreational purposes, not to have a meal, no other reasons, only for work purposes. The court will need a writing from the employer, the manager, or the owner saying that that Leo's, the business, consents to having him on the premises. Defendant must contact pretrial services the Tuesday 3 on March 11th 25 by 3:00 p.m. to set up testing.
Where do I go? You know?
What is the telephone number? She's going to give you a telephone number.
The telephone number for pretrial services, it's a new number, is, do you have pen and paper, sir?
I do.
Okay.
Okay, it's 24.
All right. I know it's pretrial services. I don't think anyone's going to harass a court number, but you know what? Just to be safe, we're going to mute it out.
2316.
Hold on.
We'll set this matter for a pretrial. The notice to appear will be sent to the Main Street address, and you will have assigned counsel. Is there anything further requested or required of the court on this arraignment, counsel?
I just want to know my next court date,
Nope,
please.
1 second, please. Ms. Blakeney, can you unmute yourself?
Yes, I'm all set.
Okay. Sir, you're going to receive your notice of your next court date in the mail to your Royal Oak address. It'll have a pretrial. It'll have a different Zoom ID than you used today. Okay, so when you get the notice, you'll have assigned counsel check the notice for the proper Zoom ID, and because it won't be this ID, because you're going to see the trial judge the next time you appear before the court. Okay.
All right. Thank you.
Thank you so much. Take care. Be well.
You as well. Take care.
Okay, Ms. Blakeney, you have
All right. That was just a little warm up. Yeah, I don't think that guy has a job anymore. Especially how his attorney said, "Oh, it slipped his mind that that's where he works." No, you got fired. Yeah, I mean, because they have to talk to someone in charge to trespass you. They don't just the police don't just randomly trespass you. They walk up to someone working and said, "Do you want him trespassed?" That's how that works. At least that's how businesses work. Anyways, now we're gonna move on to the clip that's on the thumbnail. And my first comment about this is the guy in prison. His background might be the sweetest background that I've seen on a Zoom hearing. Just saying. Just saying. This one's weird though, guys. You know what? I'm not going to say anything else. Let's just go.
To go on the record in Justin Thurber versus Jose Lopez, Lisa Porter, and Sarah Madgwick. It is 2024 CV 136, Butler County District Court. The petitioner is an inmate of El Dorado Correctional Facility. He has filed this civil case 24 CV 136. A petition was filed in this matter on 7/11 of 24.
All right, you guys are awesome. Thank you so much. None of your business. Very generous of you. 10 gifted memberships. Welcome to the 10 new members. None of your business. That is awesome. Thank you. And Terry Barnes. Good to see you, Terry. Happy Friday to you as well. Good to see you, Terry. Wait, I already said that. No, I'm just repeating myself. Terry, Nunya, thank you so much.
Counsel, would you please announce your appearance?
Yes, Marcus Meyer here for the defendants, Your Honor.
Okay. So you have filed, before we proceed to discovery or do anything else, you filed a motion to dismiss, correct?
Correct, Your Honor.
All right. You may argue your motion.
Yes, Your Honor. Good morning. Yes, we are here today on a motion to dismiss in somewhat of a unique circumstance. Here, plaintiff filed the 120-day notice as a petition, which is procedurally incorrect in that it completely bypasses the 120-day notice provision. And per the docket, the court has treated this initial filing as a petition. And if such is going to be treated as a petition, plaintiff failed to plead any attempts at informal resolution or compliance with the grievance procedures, or that he has exhausted his administrative remedies, which is a requirement under Kansas regulations. And additionally, we can now see from plaintiff's response to the motion to dismiss that his primary claims include a claim of deliberate indifference under the 8th Amendment of the U.S. Constitution, and additionally a retaliation claim under the 1st Amendment of the U.S. Constitution. And as such, these claims are not properly filed in the federal courts. And the issue with that is that since the procedure has been disrupted and defendants did not necessarily know what to make of the initial filing, plaintiff has prejudiced the defendants in that they can no longer, or that they are no longer able to remove this case to the federal court due to the elapsing of the 30-day removal deadline. And we see that allowing the plaintiff to amend this filing does not necessarily cure this prejudice due to the elapsing of the 30-day removal deadline. And Your Honor, this is generally why we believe that dismissal would be appropriate in this case.
I'm not sure that I understand in reviewing this case whether Mr. Thurber, and I guess I'm getting into some substantive matters and we're not really there yet, but
I don't want to say too much because there's a lot of confusion in this, and even Judge Satterfield is she's confused, and I don't want to spoil it because if I start breaking it down, it's going to ruin it. The prisoner filed a lawsuit basically against the prison, but I think he filed it against individuals in the prison. So it's not just the prison in general. And the plaintiff, so he would be the plaintiff. The attorney, the guy in the top right, is representing everyone on the lawsuit. But this is all over a root canal that he may or may not have received while he was in jail. Just wait for the details.
this tooth 14 he's referring to whether that was the so-called failed root canal, whether that was a root canal that must have been performed before he entered into the facility. And so, x-rays upon initial admission in 2008 or whatever it was, would reflect that he already had a root canal.
Yes, Your Honor, that was what we understand as well. But if looking at the petition, some of plaintiff's claims include falsification of such documents and claims of deliberate indifference under the Constitution. And that's kind of what some of the substantive claims are of this petition, in that plaintiff is alleging the falsification of documents by my clients, in addition to this root canal, which he says was performed in the while incarcerated, and that he's being retaliated against as well.
They look at.
Yeah, Judge had to go
in
get her law
here.
book.
I hope it is in here, but it might not be.
All right, I think there's a little bit of downtime. Yeah, there is. I'm going to fast forward a little bit, guys. Yeah, she's reviewing. So this guy, the guy in jail, is that he's saying, I might be backwards here, but he either had a root canal before he went to jail, and then the jail said that they did the root canal on him, or it happened the other way, where he had a root canal in jail, but now they're saying that they didn't give him one, but I guess he has complications from that, and he's claiming that he's being harassed because he's calling these people out for this. I think that's basically what his lawsuit is saying. That he magically either had a missing tooth or the tooth grew back. I know he said something about that here shortly. But it's a weird one. I told you guys it's a weird one. And this is the case where I said it might have merit.
So your position under 12-105B is that if he had a claim against an employee of the government, of the state, before he could bring an action under the Kansas Tort Claims Act, he needed to file a written notice. And this says with the clerk of the governing body, which contains the following, and it's one through 5, I believe. And you're positioning that the governing body that this notice has to be sent to is whom?
You 105B. It would be the clerk of the court, Your Honor. But our position is that this notice that was filed was filed as a petition and not as a notice.
Sorry guys, I left too much dead time in this.
Okay.
Hey, you got your welcome message right. You were on the wrong channel there about 30 seconds ago, peeps. No, it's on me. The clip wasn't that long, and I don't remember this much dead. I remember the one dead.
This was amended.
All right, hold on. Yeah, there was one dead air spot for about a minute, and I forgot to take that out. I didn't know there was a second one.
And how would the state be prejudiced if he were allowed to amend the notice for a petition?
Yes, Your Honor. Well, if the notice was amended, the 30-day deadline to remove has already elapsed, and we see that there are a significant amount of federal claims, and the primary claims, as he stated in his reply, are the federal claims, and where the 30-day removal deadline has already elapsed, an amended petition would not allow us to remove this to federal court, where it should be properly litigated.
All right, Mr. Thurber,
Yes, Your Honor.
your arguments?
Yeah, this is a 120-day notice. The day we had our last ruling, page 4 of my plaintiff's motion, opposition to dismiss, and Richardson versus Wagergen is very similar to this case we have. It's over a federal case. It's in federal court, but you must exhaust all state remedies, which in that case, she had to exhaust the outrageous conduct causing severe mental distress. So she was required to exhaust that first. And then she could proceed with the deliberate indifference case that she had on hand. And this case, the 30-day removal for deadline to federal court is wrong because both state and federal courts are proper for 1983 actions. Goldbarth versus Kansas State Board of Regents, 269, Kansas, 881, 9, P3D, 1251, 2000, and Lower versus Board of Directors, 274, Kansas, 735, 56 P3D 235 2002. So I can file a federal action in state court just as I can in federal court. So there's no reason I can't amend if he's saying that this is short for any reason.
The attorneys for whoever he's suing is saying that they're filing a dismissal because he didn't file it properly, essentially. That's why he's saying that. The judge is saying that's probably going to be the best way to do this, because the judge is saying you may have a case here, you just filed it incorrectly. So now he's arguing that you can amend it. I shouldn't have to refile it. You can just amend it. That's what he's arguing right now. But the guy in jail who has a really sweet background of the American flag and the eagle combined, he's the one who filed the lawsuit.
So me to be removed to federal court is completely bogus because I can file a 1983 in state court just as I can in federal court. And for anything, the defense does not dispute the deliberate indifference, nor do they dispute the retaliation claim at all anywhere. This is a 120-day notice, and the summons say it's a 120-day notice, and it's required for the negligent infliction of emotional distress for me to exhaust the 120-day notice before I go forward with it. And that's what I have done. I've exhausted that, and then I can proceed with the deliberate indifference, the retaliation, and the emotional distress. So I stand on my motion to dismiss, and if anything, I should be allowed to amend any deficiencies, and I can provide both this court and the defense copies of both grievances that are fully exhausted. And I ask it to have until April 22nd to file that amended and get that to you guys.
Wait, Jenna, maybe you're
Well,
right.
interestingly enough, the purpose of the notice under 12105B is to avoid lawsuits if at all possible, and to provide compensation potentially if the government believes it's appropriate prior to the cost of litigation or filing a case. This is the first notice that I've seen actually filed in district court. Usually the demands made upon the Department of Corrections. But be that as it may, the court could also dismiss this without prejudice. Your notice provisions would be substantially complied with, and you'd have a new lawsuit where you'd actually file an original petition that states a claim, first of all, for relief, and additionally should lay out what your monetary damages are or what damages that you are seeking. So you don't get, generally speaking, monetary damages from a personal injury case unless you can show harm.
Yeah, this is a deliberate indifference. This is not a personal injury because continually to this day, they've still hidden the fact that the drill bit is broken. And I to go over something. You stated that I came into prison with the root canal. Actually, I came into the original it's called Panorex X-ray has shown, if you want to go off of what the defendants are claiming, they're claiming that the Panorex X-ray shows a root canal prior to me coming into prison, but it also shows me missing 16, 17, 19, and 32, which I've signed consent when I'm here at prison to have those pulled by Dr. Lopez and Dr. Straight, which is the dental surgeon that came in here. So I cannot have these teeth pulled at the facility and come into prison missing these same teeth. It's physically impossible for a human being to regrow teeth and have them re-pulled that he came into prison with, which is a clear sign that they have taken the Panorex X-ray from December 15th, 2021 and put it in place, the April 2021 one, to cover up the fact that the root canal was done at the facility, at the El Dorado Correctional Facility by Dr. Lopez.
All right, so what I think that I'm going to do in this case is I'm going to dismiss the case without prejudice as the petition has not been properly filed.
I got one
And
question.
does
It's just
not meet the requirements. And you can file your new lawsuit referencing this one as far as your compliance with all statutory requirements.
right, but it's just as in for judicial economy, just as in the case I quoted, the Richardson case, they quoted that you should be allowed to amend just for judicial economy, and it's a very similar situation to the situation at hand on this situation, which would be a lot better just to amend this petition than to dismiss it.
Well, I understand it'd be, I don't know about judicial efficiency as much as it would favor you as far as expense and filing and service and that kind of thing. We're so early on, I don't even think judicial economy has become an issue at this point. Secondly, my recollection of removal allows a plaintiff to file for removal. I mean, in other words, if they think there are legal claims that are more appropriate in federal court, they have a right to argue that. That doesn't mean the federal court's going to take the case, but I think they have a right to request removal. I would have to look at that issue again, frankly, because this is a little bit unique in terms of the claims and the way you filed it and how it's postured. But I don't think it's just you that gets to decide where the proper forum is. I mean, I think they also have a right to request that it be removed and allow the federal district court to look at it and decide if they're going to accept the case or not. Right? And they
Yes.
can't do that if they don't have an actual petition. And, you know, you're going to have to claim some, you know, sometimes it's just monetary damages in excess of 75,000. That's all you get. But you have to make some financial claims so they know what they're defending. In other words, if an inmate made a claim for $100, they might just decide to pay $100 as opposed to defending a lawsuit with some unknown amount.
There is monetary claims in this what I call it 120-day petition. I'm pulling it up now.
350,000.
Yes.
Okay. Did you see that on page 24, Mr. Meyer?
And then
I think, Your Honor, in the copy that our clients received was served, I think looked at, we did not see that either. But I think regardless of that, you know, our clients, due to the unique circumstances, we haven't had an adequate opportunity to remove this case still. And I think that's kind of our main concern. We're definitely agreeable, and we're obviously fine with, you know, dismissal without prejudice to allow, you know, some of these deficiencies to be cured.
Yeah,
but
Mr. Thurber, I think that's the appropriate
All right.
way. The only reason I took up the damage issue is I didn't really want you to refile a case that was delinquent or deficient again
All right.
on procedural matters. So I wanted to make sure that you understood that you need to make a damage claim. And
Right.
I see on 24 that you have made a claim. I don't know that it,
24, 25, and 26 and 7.
Yeah.
There's 3 different claims.
okay. So requirement.
No. No. Jedi, I thought you fixed this. I thought you fixed this, Jedi. Yeah. I don't know. It just dropped for a second. It's early though. It's early, so maybe it wasn't that, and it's just a regular hiccup. I mean, they do happen. While I'm paused though, Mary Brown, good to see you back on your original account. Good to see you, Mary. Thank you for hanging out with us, and thank you for the super chat. I appreciate it. Okay, I'm gonna keep playing because I think that was just a regular hiccup. I don't think it was the normal one that I usually get. I think that was just, you know, yeah. We're almost finished with the case anyway, so let's go.
File your petition.
But
Okay,
most-
and
but I
I
can file
would reference 24 CV 136 as the mechanism in which you've met your statutory
will.
requirement to give notice.
All right, I will.
Okay, all right. If there's nothing further today, we are adjourned.
All right, thank
I'm
you.
dismissing this without prejudice. You can appeal if you wish, or I think it'd just be easier to refile.
Yeah.
All right. Apparently apparently they cut the audio at the end. Legal Fiction, thank you so much for the $5 super chat. And yeah, no, the video froze. My whole internet froze. But yeah, it bounced right back up really fast. So I think that was just a random hiccup. I don't think it was anything to worry about. Let's move on. What is the next case? What is the next case? You know what? I don't know. Let's play it for a second. See if I have to give any context real quick. Oh. Yeah, Judge Simpson. I don't need any context with this. You guys will pick it up real quick. Let's just say this guy might be one of the most honest defendants I've ever seen. Not in his favor, though. All right, let's go.
Court calls the case People versus Adam Watkins.
Henry Silver on behalf of Pittsfield Township.
Okay. Hello, sir. What's your name?
Adam Watkins.
Okay. I had issued an order to show cause. You have not been arraigned on this case, and I want to arraign you on the charges or the charge. The citation alleges that on or about January 7, 2025, at the location of Michigan Avenue near US 23 in Pittsfield Township, that you were found in possession of drug paraphernalia contrary to Pittsfield Township ordinances. Do you understand the nature of that charge, sir?
Yes, sir.
That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, please.
All right. This is a public defender case.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Watkins. We will waive further readings, standing to the charges, and ask for another pretrial date, please.
And then every waive formal reading, the court will enter a not guilty plea. Pretrial in this matter will be adjourned to March 19th, 2025, 9 a.m. or as your invite indicates. Set the defendant's bond at a $5,000 personal recognizance bond. I will order. Yes, sir.
I'm going to be in rehab. I got next 10 days. I'm going to be going into rehab for at least 30 days.
When are you going in?
Within the next 10 days. I'm in the process.
Yeah, go ahead. I don't care.
Subject of getting hold of the number to the distribution center.
Okay. Where are you doing this rehab?
This is for Plymouth, Canton Township.
The court?
Yes.
Okay. Do you have paperwork indicating that?
On me, I do not. I just went to court yesterday for it. It's either 30 days in jail.
Here's what I'm going to do. You're going to need to get that paperwork to your attorneys here. Okay, so that they can show the court, but I'm gonna leave it set for the 19th.
Within, they bring it up here to the court. I feel like I'll have it within the next couple of days. You know what I'm saying? They're supposed to be sending me the number from Canton, for the distribution center. And then I'll know exactly, okay. To you, okay, thank you. Yeah.
All other standard conditions, including no assaultive behavior or possession of any weapons. There should be no alcohol, recreational marijuana, or illegal drug use. You understand that, sir?
Yes, sir, Your Honor.
I will also sign an order for community corrections regarding testing. At this point, it'd be 2 times per week, but if you're in treatment, then go with that. If I were to give you a test today, you gonna come back clean?
Nope.
I didn't think so. What have you been using?
Okay. It's been 3 days or so, but it's still probably come back dirty.
What do you mean it's been 3 days?
I haven't used anything in the past couple of days. But it's still, I don't think it'll come back clean, to answer your question.
Well, your bond on your other case in Plymouth, you're not supposed to be using.
Yeah, this is all right.
What?
That's why I'm going into rehab.
Are you testing out there?
Not to just starting everything. I just went to court yesterday.
Let me just tell you. Okay. I'm gonna tell you right now, Mr. Allen. Young man,
Yes.
I'm going to ask you this. I'm going to ask you this once.
Yeah.
When was the last time you used?
It's been about 4 days, to be honest with you. Yeah, the honest answer is I can't give you an exact date, but it's been within 3 or 4 days, Your Honor. To be completely honest with the courts. That's one of the reasons I'm going into rehab. Because of my lack of control.
Where are you going to rehab?
I'm still, I gotta get a hold of their 34th is sending me the number to the distribution center. I haven't gotten it yet. As soon as they get it to me, I'll know exactly then. And I can give the courts the information that I have at that point in time.
When did 34th order you to?
No, not 34th, 36th, Plymouth. Yesterday. I was just in court yesterday.
Okay. And they ordered you to rehab?
Yes. Is it 30 days in jail?
What judge?
Your Honor, I found the case, if I may.
Yes, go ahead, Mr. Barron.
It's before Judge Giroux in 35th. It does look like he appeared yesterday and pled. Their ROAs look a little bit different than ours, so it's a little bit difficult to understand. But it looks like he was sentenced yesterday at noon. It says optional jail term, but that's all I can really see. Optional term 30 days. But it looks like that's all it says really about his sentence.
But it doesn't say anything about treatment?
It doesn't really tell me. Well, it says probation. It's pretty unclear. It says there's a bunch of entries with description. It says crime rights assessment. Oh, those are the fees. Optional jail term, probation, monetary transaction. He paid $125. Scheduled to report to jail 6/20/25. So that may be what he's referring to when he says.
You got a jail sentence?
If I may, Your Honor, my client seems to be the understanding that if he were to complete the inpatient rehab, he would not have to do that jail sentence, which I believe that might be why then his report date is in June 2025. If so, maybe that jail time will not actually be imposed if he does that rehab.
Right, because it says optional term.
Yes, Your Honor.
I can print out.
Do they know you've been using?
No. I think that's why I chose to go to rehab versus going to jail. I think rehab would be better for me than going to sitting in jail for 30 days versus going to the rehab. That's what I need. I think personally.
Well, I understand that, but that's not my issue right now. Did somebody bring you here?
Yes.
Okay, so, but my question really is, does the other court know that you've been using?
No. They've not dropped me yet.
Pardon?
They've not dropped me, no, sir, Your Honor.
Did you talk with anybody at the other court, their probation department, anybody?
Yes, I have.
Because I'm going to be honest with you, sir. I think when you give me that 3 to 4 days, I think you've used more recently.
No, sir.
Just by the way that you're acting.
No, I've not used today at all. I've not. I promise, of course, I'm going to use. It's been at least 3 or 4 days. Minimum.
Yeah. I agree with Judge Simpson here. This guy's bouncing around. He has the sniffles real bad. And for people that are dependent on a substance, they know exactly how long they've gone without using. It wouldn't be 3 or 4 days. It wouldn't. Sorry. He would know exactly the last time he used, and he would, if he wanted to be sober, he would remember that time, and he would keep track of his days from that time. Yeah, I don't believe it either.
I'm a little nervous right now, to be honest with you.
All right. Well, here's what I'm going to do. I'm actually going to set the defendant's bond at a $15,000. I'll just do a 10% bond, but if he's got it, he can pay it. I'll set a special pretrial, or at least review of his bond on March 12th, 2025 at 9 a.m. That's my sentencing docket. But that way he's not in the week. Ms. Payton, Ms. Farroney, if you get information more specific for me from the other court as to what he's supposed to do, then I'll consider his release. But at this point, he's not leaving here.
Yes, Your Honor.
It's been 3 to 4 days since you've been here? Really? I don't believe you. I don't believe you at all. You're here every night, Deval. I would notice if you weren't here. I would. All right. I don't even know what the next case is. Yeah. Yeah. Anyways, let's just move on. I think we're moving on to the last case. We're going to Judge Perkins. Okay. We're gonna end the night in a little bit of a funny way. You know, it's Judge Perkins. This guy. You know what? I don't have to say anything. We all love Judge Perkins. Speaking of which, you know what? Nope. Not allowed to do that anymore. No, can't do it. Can't do it. Keep my mouth closed. I spoil everything when I talk too much. So I'm going to stop talking. Let's go.
With Mr. Gailliard. Mr. Gailliard, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, my client is aware of his trial rights. However, he would like to enter a guilty plea and accept the people's recommendation to amend it to allowing an unlicensed driver to drive. And I would like to speak as the sentencing when it's time.
Raise your right hand, sir. Swear or affirm, tell the truth, whole truth, nothing but the truth.
Yes.
You can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fine?
Yes, Your Honor.
You understand that you have an absolute right to a trial?
Yes, sir.
Ms. Bradfield went over your other advice rights in the breakout room, did she not?
Yes, sir.
You understood those rights?
Yes.
Any questions about those rights?
No.
You know, by taking the deal, you're going to give those rights up.
Yes, sir.
Has anybody offered you anything other than what's been stated in the record?
No, Your Honor.
All right, let me draw your attention back to January 3rd, 2025, around 4:20 p.m. in the city of Detroit, area of Lafayette and Griswold. Have an occasion on that day to come encounter with the Detroit Police Department?
Yes.
We're operating this motor vehicle,
Yes.
and did the officer have to ask you to produce a valid driver's license?
Yes.
You couldn't do so, could you?
No.
And why is that?
Well, I was unaware that I was being sued in a lawsuit.
Because you didn't have a license, so you just didn't know you didn't have a license, right?
No, I didn't know. I didn't have a license until I was pulled over.
You're not contesting the fact that your license was valid at that time, are you?
No, I'm not.
Okay, very well. Find your client guilty of the amended count of allowing. Go ahead and allocate on your client's behalf, Ms. Bradfield.
Your Honor, I would like to ask for leniency in this fine. Mr. Gailliard did not know until he was stopped that his license was suspended due to a lawsuit and a subsequent default judgment that was entered against him. The lawsuit and subsequent default judgment happened when
Dang, DL, I tried to gift you one. It missed you. I'm sorry about that, but I tried. I know iOS, any Apple devices. I know there's a way to do it, but you have to do it a weird way to be able to be a member on an Apple device. People have done it in the past. It's not as easy for some reason. I don't know why.
He was incarcerated in another state, so he had no knowledge about it. And he has to enter into a significant payment plan with Progressive Insurance, or at least try to see if he could get the default judgment set aside. And I know that's going to take money. And so I'm asking if the court could please waive his fine in this matter.
Well, let me ask you this, Mr. Gailliard. Whose car is that?
It's my wife's.
You see what I'm saying? You didn't see the ticket. If I correct, is a 2000, is a Porsche?
Yes.
That's Mr. Bradfield. He's driving a Porsche.
Dude got a ticket in a Porsche, and Miss Bradfield is asking him to lower the fines and costs. Yeah, just look at that face on Perkins. It's not gonna happen. Not gonna happen.
Pardon?
He's driving a Porsche.
It's a 2006, if that helps.
I don't care what it is. Last time I checked, that's more expensive than probably a 2020 something.
I don't know. The Blue Book value is 10,000.
And Your Honor, it's me requesting this on behalf of my client, not something my client asked for.
All right, you gonna use one up on that one, huh? Well, it's difficult right there. What kind of leniency are we talking about, Ms. Bradfield?
I'm asking, Your Honor, I'm gonna go for the gusto. I'm asking for a waiver of the entire fine.
How much money do you owe?
The default judgment was for 15,000.
Just sell a goddamn car.
That's not a lot of money. In a sense, you got.
Oh, did you hear Bowman's little hot mic moment there? Sell that damn car. Mr. Bowman, he hates the mute button. He always keeps that unchecked.
I don't know, Mr. Brown. I think he's very capable of making just payment arrangements. Are you working, sir?
Yes.
Where do you work?
I own a clothing business, and I did have a dispensary, but not anymore.
Your Honor, may I ask a question?
You may.
You say this default judgment is against Progressive Insurance Company?
Yes.
Did it come arising out of an automobile accident?
Yes.
Where you were a judge to owe various amounts of money pursuant to injuries from this automobile accident?
Honestly, I was unaware of any.
Did you have insurance on any vehicle at the time of this accident?
Yes.
All right, thank you.
What was the purpose of? No, wait a minute. Wait. Other than you want to show your vast knowledge of the no fault law.
That's exactly what this questions were
That's
about.
what we did. We just wasted another couple of minutes on that line of questioning because I don't know if we gleaned anything from that.
What we gleaned, Your Honor, is that I thought that his judgment was going to be significantly more than $15,000.
No, I think the default is default. You know, when they say default, they've already attached the dollar amount on that when the default is. It could have been less had he showed up for court, and you didn't show up for how much time did you do in incarceration?
A year.
All right. Did you run the red light?
No.
That's the wrong answer.
That's the wrong answer.
I wasn't at a red light.
He said he advised on disregarding traffic control devices.
Oh, you mean
You
with the
talking about the
ticket?
current ticket?
Oh, yes. Oh, I made a wrong left turn. Yes.
Yeah, that's running the red light. Lafayette and Griswold. I can't do it. Not in this case. I think Mr. Gailliard very capable of paying this. He owns his own business. I know times might be a little slow, but he seems like he's very capable of coming up with 240. Am I correct, Mr. Gailliard?
It'll be taken care of, no problem.
There we go. I know it is. I know it will be. I'm 240. I'm going to dismiss the amount payment. Nice try, Ms. Bradfield. I don't fault your attorney for trying. That's what she's supposed to do. That's her job. When can you pay it?
Can you give me a week?
Yeah.
All right. Yeah, the attorney was asking for no fees, and it's only going to take him a week to pay it. The problem with that is now that she used that argument on him, the next time she uses that argument, the judge is going to question her. All right. That's about it, guys. There's about a minute left. I'm going to let the rest of it play out. I'm going to go look for someone to raid. I see Lone Wolf was hanging out here, so maybe we're going to be raiding him. We haven't raided him in a while. It's not like we raided him every night this week so far. So, yeah, we're probably going to be raiding Lone Wolf. But thank you guys so much for hanging out. I do appreciate it. I know Nunya just gifted 5 more memberships. Thank you so much, Nunya. Welcome to the 5 new members. Nunya, you were awesome tonight. Thank you so much for your generosity. And all the new members, thank you guys for hanging out. All right. I am going to go find someone to raid, and we're going to peace out. If we're raiding anyone besides Lone Wolf, I will pause it right at the end and let you know where we're going. But it's most likely going to be him. KCC just went live. Well, it looks like we might be raiding KCC then. Let me go look to see the list. Let's see what we have. And you know what? I'll just pause it right at the end. There's still a minute left, so I'll let it go.
Hey, if I come back next week, if you pay it any DivDat kiosk in the city of Detroit, I'm told you can upload the DivDat after your phone, or you can come on down to the courthouse and pay it in person. Those are the 2 best ways I can tell you to pay it. So let us know what kind of clothes you sell. This is your plug right here.
I sell sweat outfits, t-shirts, pants. I'm trying to get into the women's, but I got all men's right now.
Now, how do we go and check out your lineup?
You could go on Instagram, check out my Instagram. I have 2 other business pages on Instagram people could check out.
How am I supposed to know how to get to your Instagram?
No, it's the Kush Monster. That's the name of it.
Monster.
Yes.
And that's related to that Bruce Kush.
Yes.
I don't partake, but I do know a little bit about it.
Hey, knowledge is everything.
All right. Mr. Gailliard, best of luck to you. Come back March the 14th, 2025. Pay at any DivDat kiosk in the city of Detroit. I'm told you not supposed to DivDat after your phone. Or come on down in person.
Question, after I pay, then come back on the 14th?
If you paid and you pay in one of those 2 ways, it'll go through immediately and I'll see it here and you don't have to come back. I'll dismiss the case. But if it's not paid, then if it's paid like online or something, it takes an awful long time online. So pay it at the kiosk, did that, or you come on down to the court, then it'll go through immediately.
Okay, perfect. Thank you.
All right. Best of luck to you.
Okay, thank you.
All right, there you guys go. Kush Monster. If you guys want to go check out his clothes, Judge Perkins allowed him to drop his plug. So, you know what? Kush Monster. There we go. All right. We are rating KCC tonight. She did just go live, so we're going to go hang out with her. Make sure you tell her I said hello. And I will not see you tomorrow. Tomorrow night's date night, so I will see you guys on Sunday night. Yep, Sunday night it is. Again, thank you guys so much for hanging out. I do appreciate it. You guys are awesome. Thank you for the super chats. gifted memberships, membership milestones, all the goodies. You guys are awesome. And until next time, bye.
Thank you. Appreciate it.